Afide, good morning. You may be seated. Will the clerk please call the case?
This is Supreme Court case number CRA24-025, People of Guam Plaintiff Appellee v. Luis Anthony Vargas, Defendant Appellant. Appearing for Defendant Appellant is Attorney Stephen P. Hattori. Appearing for Plaintiff Appellee is Attorney Christine S. Tenorio. The panel consists of Chief Justice Robert J. Torres, Associate Justice F. Philip Carbolito, and Associate Justice Catherine Merriman. Your Honor, Attorney Hattori reserves 10 minutes.
You may proceed, Mr. Hattori.
May it please the court. So the issue presented to the court today involves what a trial court judge should do in the case of hung jury, basically. The facts of this case are pretty undisputed. There was a 13-day trial involving 6 expert witnesses, a very sensitive complaining witness, as well as numerous witnesses on behalf of the defendant. The deliberations themselves didn't last very long. I think they were instructed and returned a verdict, or at least a partial verdict, within 2 days. At the end of when they returned a verdict, they basically came before the court and said that we've reached a verdict. The judge read the verdict forms and then asked a series of questions like, you only marked one, what about the rest of them? And he basically limited his inquiry to the foreperson. And
is the defendant's consent or a declaration by the trial judge of manifest necessity required to declare a mistrial when there's a hung jury?
Well, in a case where there is not, the defendant did not move for the mistrial, or where there's not an express intelligent knowing waiver of the double jeopardy claim, then I think that there needs to be a finding of manifest necessity.
Well, when we look at 9 GCA 1.24, and the government makes this argument as well, that there are 3 grounds in which termination is not improper, right? One is consent of the defendant, or whether he moves by motion to dismiss or waives by motion to dismiss. One is where the court finds that it's necessary because of the failure to agree on a verdict. And then the third is it's required by a sufficient legal reason and a manifest or absolute necessity is present. So it seems like there are 3 different grounds for proceeding where termination of a trial would not be improper. And so in this case, was the defendant's consent obtained or not? I mean, do we fit within that parameter? And what would we look at for purposes of determining whether there was a consent by the defendant? Because that's one of the things they argue. And then also, if it was a D2 provision and it was just based on there being a hung jury, are you still looking at the statutory language? Are you suggesting that we still have to find manifest necessity?
That's correct. I think that the manifest necessity is a constitutional standard that would trump the statutory language. And I'm not sure if the statutory language.
Do you have any case where an appellate court has overturned a trial court's declaration of a mistrial on the ground that the manifest necessity standard had not been met?
Okay, so in this case, the trial judge didn't actually make a finding of manifest necessity explicitly. And I think he basically seemed to agree with the government that since he already read the verdict, he can't go any further. And based on that, ruled that he's just going to declare a hung jury.
And I'm glad you ended your sentence with that word, those words. So wouldn't manifest necessity be presumed if there's a finding on the part of the trial court that there is a hung jury and on that basis terminates the trial?
That's correct. I don't think the phrase manifest necessity needs to be stated by the court, but I think there should be a sufficient record so that when that decision is reviewed de novo, that the court can actually say that there is a record to support
While
manifest necessity.
de novo, we review the question of manifest necessity. De novo, isn't it the standard of review and abuse of discretion as to whether or not the trial court in reviewing the factors, whether or not the trial court abused its discretion in making the decision that it did, that the jury was hung, that there was a hung jury?
I understand the abuse of discretion standard applies in some of these cases, but where there really isn't particularized findings for the Supreme Court to actually weigh and determine if their discretion was abused, I think a more general standard should be applied. For example, if he made a
You're not
specific
suggesting,
finding.
are you suggesting, Mr. Hattori, that we exercise our discretion, replace the decision of the trial court in its articulation of the facts that led it to conclude that there was no further reason to proceed and declare a hung jury, that we can disregard the trial judge's discussion and review of the various factors and just decide this on our own?
Well, I think that might be going a little further than I think is necessary, at least in this case. I think what guided the trial court's decision was an erroneous reliance on a particular law that doesn't exist, and
Which is
that if once he reviews the verdict that he's unable to proceed and issue Allen charges, and that is automatically de facto coercive once he's made aware of what the actual verdict is. And we believe that was a misstatement in law that.
But you didn't address that at all in your briefs, whether or not the argument that the Allen charge was unduly coercive. You didn't argue in your briefs at all why that was or wasn't the case.
Well, I don't think we never were able to get to that point at the trial level. And because we were stopped at that first point of where the court made that determination that we weren't even going to be able to argue that, because he already made a ruling that since he's reviewed the verdict, he can't conduct further inquiry.
Yeah, but if you're asserting now that the Allen charge would not have been coercive and he could have given it, I mean, don't you think you should have fleshed that out on argument if you're trying to argue now that that was one of the reasons the court proceeded and it was wrong for him to do that?
That's correct, Chief Justice. We believe it was fleshed out in the sidebar. I asked.
No, but I'm talking about on your brief on appeal.
Oh, we did argue goading by the prosecutor in misleading the court into and we cited Brazil for that proposition, Green, and also the People Guam versus Pablo case, although that one the Supreme Court didn't actually find goading because in the Pablo case they did not determine that the government's intent was to encourage a mistrial, whereas in this case the argument that you can't provide an Allen charge where the trial judge has read the verdict was made for the sole purpose of encouraging the trial judge to issue a.
I thought, Mr. Hattori, you stated on the record, if I recall this correctly, that you didn't think that the government may have, as you alleged misstated in bad faith, and that may have just been a mistaken statement of the law. But then I don't think there's anything in the record where you stated what was the correct statement of the law. And so that the trial court can reconsider its thinking in reference to whether or not the factors, the various elements that it did, the facts, warrant him declaring a hung jury.
That's correct. I do recall the record supports that I was trying to raise that issue. Then I was cut off by the government, and the government said, well, Your Honor, you can't really do the Allen charge because you already know the verdict. And then the judge basically took her argument and said he's going to declare a hung jury, which I said, okay, because at that point he made a ruling.
So it's your argument this morning that the part of the transcript that reads indiscernible, there were two instances where it read indiscernible, that you attempted to make an effort or that you did relay information that the trial judge should continue with interacting with the jury in reference to trying to give the jury an opportunity to continue its deliberation.
That's correct, because the record shows is that I said maybe we should ask them, send them back for further deliberation. And that's when the government interjected and said, you can't send them back because the court's already read the verdict. And so it would be unduly coercive for the court to issue an Allen charge if they know the.
What about the other findings of the trial court that it asked the question, I think, of the foreman, why the boxes were not checked in reference to 9 other charges, and the foreman just responded that in the affirmative that they just couldn't come to a decision.
That's correct. And then the judge said, so you were hung. And
so would that be enough for the trial court then to make a determination that and declare a mistrial on a hung jury?
And that's why further inquiry was needed. When you just ask a layperson or a jury foreperson, so you were hung. I don't know I don't even know what that means.
So what should the trial court have done after receiving that information?
I think the trial judge at that point could have asked if continued, because they hadn't been deliberating very long, right? The trial judge could have asked if you guys need a break. Do you think continued deliberations would result in a verdict? Or are you saying that at this point it would be unreasonable to have you continue deliberating? But I think just asking the foreperson, so you're hung, that I don't even know what that means. I think lawyers argue all the time about whether a jury's hung or not. And so I don't think he even asked like, how close are you to a verdict? I know that he's not supposed to poll the juror, but there were a lot of preliminary questions he could have asked, or he could have just done what he's done in prior cases and issued a general Allen charge, but it wasn't even offered once. And I think if you read the transcripts, it was kind of interesting because let me quote the record. When the trial judge was questioning the jury or polling the jury, and we believe that he must do more than polling a jury to establish manifest necessity. He just asked, okay, is that your verdict as read? Jurors say yes, and then and the court said, say yes. The jurors said, say yes. The court said, okay, and on the others, you did not reach a unanimous decision. Is that correct? And then there was no audible response, and the court said, yes, question mark, say yes. And so we know what the court's understanding of what the juror said, but it wasn't a true polling in terms of hearing it from
But
the jurors.
the court has pretty broad discretion whether to declare a hung jury, right? I mean, and getting back to the question, once it's made that decision to declare a hung jury, and the question is just, isn't there a presumption that manifest necessity standard was met? I mean, I haven't seen a case where there's been a hung jury and a determination that there was no manifest necessity or had not been met when the judge has already declared that there's a hung jury.
Okay. And so I think that's, in this particular case, it seems like there was the hung jury was declared before, or I think a record was made for it, and that's what we're concerned about. We believe there should be some standard.
But I mean, then you're challenging the discretion of the judge to declare the jury hung, which is different than was there manifest necessity? And you know, it seems like the cases, at least that I've looked at on a judge declaring a hung jury, are very deferential to the judge's declaration of a hung jury. And and once he's made that decision, you know, it seems that this issue of whether there's manifest necessity or not really doesn't come up because it seems that he's declared a hung jury already.
Yeah, but I do think there are two separate questions because you know, when you declare a hung jury and it's due to jurors unable to you know, agree on a verdict, I think it requires a more intensive inquiry than was conducted in.
But if you look at our statute, and our statute says the court finds termination is necessary because of the failure of the jury to agree upon a verdict after a reasonable time for deliberation has been allowed. So
that's correct.
And the judge made that determination that there was the failure of the jury to agree upon a verdict. And he felt the time was reasonable. Now, you may disagree with that, and you know, you could challenge the abuse of discretion, but that didn't seem to be the argument you were trying to make on appeal, is that he made a mistake in declaring a hung jury. Your argument was that there was manifest necessity was missing from the termination. And I'm trying to understand, when he's made this hung jury determination already, why isn't that just a presumption that there's manifest necessity as opposed to some other legal reason where that he finds that termination is required?
Yeah, so as I understand the court's not saying that every time there's a finding by the trial court of a hung jury, it's a de facto manifest necessity. It just creates a presumption. Is that what?
Well, I mean, because as I asked, my first question is, has there ever been a case that has overturned a trial court's finding of a declaration that there'll be a hung jury on the ground that the manifest necessity standard has not been met?
I know that in other contexts there have been findings.
Yeah, but I'm talking about on a hung jury context, where the court has declared a hung jury. Has any other court reversed that finding on the basis that it was not manifest necessity standard was not met?
Not in that context, but in other contexts, courts have.
But we're talking about a hung jury here. We're not talking about some other reason that the court terminated the proceeding. They terminated it because he made a decision that the jury was not going to be able to reach a verdict and termination was necessary. That's the facts that we have.
Well, that's correct. So the standard would be if the trial court makes a finding of hung jury, there needs to be no finding of manifest necessity, but in those other contexts, when they declare a mistrial, then the manifest necessity applies in those other.
Well, that's the question. I mean, and when you look at the statute, and that's why I asked, has there ever been a case where the court has declared a hung jury and there's been a reversal and said, no, the court should not have terminated because manifest necessity was not met.
Okay, that's correct. So not in the particular context of a mistrial based on a hung jury, but mistrials based on like goading by the prosecutor or other grounds where a mistrial was found. Courts have reversed, and so we just believe that the manifest necessity standard that applies for mistrial in general should also apply to the situation where there is a hung jury. And then the reason why is because the reason the double jeopardy clause exists is to it's really to protect the defendant, but it also historically was to prevent the courts from saying like, oh, this case not looking good for the government, so I'm just gonna dismiss it, declare a mistrial, and let the prosecutor try again, get a second bite at the apple. And so if there isn't an opportunity for review of a trial court's determination that a jury is hung, then in situations like this.
Well, there is, and that's looking at the decision to terminate the proceeding under an abuse of discretion standard, but recognizing that at least the cases seem to give him broad discretion as to when that is permitted.
Oh, yeah, and I don't really have much argument against the abuse of discretion standard as long as there is a standard and it is a reviewable.
We better, you have 8-9 minutes left. Can we look at the implied acquittal argument? Because I'm not sure exactly what it is that you're arguing. Originally, and in your opening brief, you were talking about count 4 of the first charge, that there was an implied acquittal of count 4 of the first charge when he was convicted of count 4 of the second charge. And that was the same argument you made in the trial court initially, and the trial court found that was charge 1, count 4 was inapplicable because it dealt with the fellatio and did not deal with the, if I recall, that charge 2, count 4 was the second degree CSC, and charge 2, count 4 was the special allegation, and count 4 on the first charge was the fellatio. And that was the argument you brought up downstairs, and the judge rejected that argument. And then now you seem, and on your reply brief, you're talking about there's an implied acquittal of charge 1, if I'm not mistaken, charge 1, count 5?
Yes, and the count 1, charge 2, which we believe are corresponding. It's the same offense. It's because they're not necessarily included. They were independently charged, but it is the same offense charged in both. So if he were convicted of both, the sentences would merge, and he would only receive a sentence for the first degree, the greater charge. And so while it is a lesser.
So you're arguing that the charge 2, count 4 is a lesser offense of charge 1, count 5,
or
rather than charge 1, count 4?
We thought it was count 1, charge 5.
Well, yeah, I know that's what you thought at the lower court level, and the trial court corrected that and pointed out that he felt you were arguing the different, but it seemed like you just used that same argument of count 4, the first charge, which was the fellatio between February 2018 and July 2018. And so I'm a little confused because even if you look at count 5, which is what maybe you're arguing, and what the trial court also, that the The problem is the jury was not silent on the first degree CSC charge under charge one, count five, because they specifically said they were deadlocked there.
Well, they said they weren't actually polled on count one, charge five. They were polled generally among all of the, but that would have been inclusive. And so, but we believe that, they may have continued deliberating when they were unable to reach a verdict on that
But
one.
this is, Mr. Torrey, the bottom line. Regardless, your argument is that second degree CSC is a lesser included offense than first degree CSC. And if a defendant is found guilty of second degree CSC, even if you were to correct the count, as the trial court pointed out, that our case law is such that that is not the case, that second degree CSC is not a lesser offense than first degree CSC. So just by the law, that is not accurate.
That's correct. I think for a particular purpose, it's not really a lesser included, because for double jeopardy purposes, it is, because it's the exact same conduct that's being alleged in both counts. And so for the implied acquittal argument, they treat it as because it's the same conduct that's being alleged, even though they're independently charged.
But we have stated that they're separate offenses.
Yes, but there's separately charged offenses, but it's the same course of
Not only
conduct.
charged offenses, but just the facts that are necessary to prove each offense. One offense contains an element not contained in the other. So you can't say they're the same. May have occurred on the same date, and it may have arrived from a course of conduct, but the way the law reads in reference to second degree CSC and first degree, they have separate elements that must be separately
I'm not arguing with the court on that.
satisfied.
I'm just saying that for in certain contexts because it's the same course of conduct, and the double jeopardy clause applies to the offense is being charged, right? The same course of conduct. So
But we
just
can't-
like when you merge the same conduct for a first degree CSC and a second degree CSC, the government even conceded that on sentencing, the sentences would merge. And that's what we're saying, just for this the double jeopardy context, that it would be, for example, if in this case, if because it was independently charged, we're just saying that the government, that the jury, when they didn't check a box, that means they were silent on the first degree charge that was identical or corresponded to the second degree charge. And under Green and Brazil, that would be an implied acquittal of that, the more serious charge. But we're not saying they're lesser included for all purposes, just for double jeopardy purposes and for sentencing purposes. And Kuman kind of references that when they talk about they talk about where lesser offenses independently charged. They talk about other concerns exist when the lesser and greater offense have been independently charged. The defendant may not be sentenced on both charges. And it has been said that where a jury has found a defendant guilty on both the greater and lesser offense, then the conviction of the greater is controlling. And so this is
But that's for purposes of
for sentencing. And we
Yeah.
believe also for double jeopardy would be, because that's the whole basis for sentencing. You're not going to punish him twice for the same offense, so they'll
that's not
merge the sentences.
that's not the context of how I understand your brief is arguing. You're saying that the trial judge could not have even considered the first degree CSC once the second degree CSC was found in violation by the jury, that automatically first degree CSC, that seemingly stems from the same course of conduct, that had to be dismissed on those grounds, not on
as an implied acquittal.
hung jury grounds.
Oh, no, we were arguing that under an implied acquittal as in the Green case or the Brazil case, where someone, they went to trial for first degree murder and a lesser included, and then they didn't return a verdict for the first degree one, but for the second degree one, they were convicted. And then it was reversed on appeal, and they tried to resurrect the first degree charge on the retrial, and it was reversed.
Let me just clarify, because it looks like you're out of time, but I'll give you 2 minutes on rebuttal. You also indicated in your review, you're just looking at the one charge under this implied acquittal, because you also said the defendant also seeks dismissal of the other charges not related to the July 26, 2018, also as a result of implied acquittal. So are you trying to encompass more charges?
Well, the law specifically what we believe would apply to that one charge, not the other.
Yeah, because I mean, that threw me for a loop in the brief when you put that in.
And that's because we believe that when the jury returned a verdict for second degree CSE, they had already considered first degree, ruled it out, and then decided to return for the same course of conduct as a second.
All right, thank you.
Thank you.
I'll give you 2 minutes on rebuttal, Mr. Hattori, even though you've exhausted your time. That's all right. All right.
Mr. Chief Justice, may it please the court. Appellate review of the trial court's determination of the hung jury is precluded at this point because the defendants did not bring this up on appeal in Vargas 1.
Why would they have appealed it in Vargas 1?
Because it would have barred the government from bringing back the charges again at a later date. Because when we moved to dismiss on the basis that the victim was not emotionally ready based on the therapist's letter, they knew that the charges could have been brought back later. So the defense's argument that it was moot or not right, that doesn't apply here because now we are going back to this manifest necessity determination only because we have now reinstated the charges.
But why was it right then? I mean, if you had never brought these charges, there wouldn't have been an issue to bring it up on appeal.
It was right then because they could have determined, they could have fought the manifest necessity. For example, before they even appealed.
Weren't all the charges dismissed to them?
It was dismissed without prejudice. Why would that have been a final appealable order?
So procedurally, this is what I think how they could have taken advantage and exhausted their remedies. If after the trial and the declaration of manifest necessity, they truly had issue with it, they could have moved to reconsider and ask the court for a ruling on why manifest necessity why manifest necessity was improper, and then we could have had a retrial back then.
But there was really no briefing here on their failure for motion for reconsideration and why that would bar. I mean, I know it's raised, but there was no case law discussing why the failure to go forward with a motion for reconsideration bars them.
So the case law that I put forward is the law of case doctrine, where generally under law of the case, if an issue could be have decided earlier that would dictate the procedures of the case, that is what I'm resting on for law of the case, because this was a case that they are only now bringing this appeal because the first conviction was overturned by the court, and then we have now reinstated the charges. So that is my position on that. But if the court determines that this is not precluded on appeal, the manifest necessity determination, one is not necessary because of the issue that the defendant consented to the mistrial. Now, the trial court analysis on that was that he consented to it because he did not request an Allen charge, because the defense counsel left it up to the trial court's discretion, and that the defense counsel assented when the trial court was about to declare the mistrial. Now, the case law here says that this doesn't have to be explicit. This is not a constitutional right where you have to pull the defendant and say, are you making a knowing and involuntary waiver of the double jeopardy your double jeopardy rights.
What test should we look at in determining whether there's been consent?
The test that the court looks at a totality of the circumstances, whether it's explicit or implicit consent. And so the case law that I had cited in my brief, it explains about you look at the defense counsel's conduct. So some cases say that if you agree to a second trial, that is you consenting to the mistrial. Now, the issue is that
Does it matter who the mistrial is for the benefit of?
well, in this case, though, the mistrial was not for the benefit of either party. It's important to understand procedurally how we ended up here. When the parties were called down to the court because they said they reached a verdict. There was no note that they were not unanimous. They said they reached a verdict. Now, when the judge was reviewing the verdict forms, he noticed that the verdict forms were not all checked. Now, while that was happening, that is when I had the discussion with Mr. Hattori about what are we going to do, because the decision had to be made before we, the parties, knew what the verdict is, because we didn't know who it was going to benefit, whether it was going to be a not guilty or guilty. And so the concern was that if the trial court saw the verdict and then told the jury to go back, they would have thought that that was coercive, like they had to vote in line with what they had already voted. And at the time, the benefit, we didn't know who it was for. So that factor was not taken into consideration. Now, although defense says, well, they attempted to request for an Allen charge, but was cut off, the only statement that was made, separate and apart from the indiscernible statements, had nothing to do with this particular colloquy. At sidebar, Mr. Hattori says, maybe we should see if they can deliberate more or something to that effect. There was one inquiry, but then we had the discussion about it may have been coercive. Now, it is also important to say that so the foreperson actually said, did we have to check those boxes because we were undecided? So the foreperson had already declared on behalf of the jury that they were undecided on the rest of the charges, which is why the boxes were not checked. Then, to make the record, the trial court actually polled them and said, even though it was a group poll, he said twice, he asked them twice, were you undecided on the rest of the charges? And they all said yes. And so that is the record that we have, that they were deadlocked. Now, defense is putting forward that the trial court needed to make a further inquiry, but a trial court has discretion to has wide discretion under case law to declare the mistrial, especially after the foreperson and the group declared that they were undecided. So an Allen charge is not required under the law, especially if it would be coercive. And the ironic thing is, the reason why I had made that suggestion at sidebar is because if for some reason he was found guilty, I didn't want to be back up on appeal where they would say, well, you made them deliberate. And so then he may have been found guilty on the rest of the charges only because the judge sent them back to deliberate. So in here, you just look at the totality of the circumstances and the conduct of the defense counsel and the defense in assenting or consenting to the mistrial. And the trial court spelled out all the reasons why he believed that the defense consented. And so that this court doesn't substitute discretion. This is, you're reviewing an abuse of discretion, which is that there was no logical basis, essentially, that the trial court could have done this. And he did have logical bases because he spelled it out in his decision and order. And so in this case, we don't even need to get to the manifest necessity determination, because if we find that the defendant consented, which the trial court did. Now, if there is an issue with the consent, then you go on to the manifest necessity standard, but that is merely once the court finds that there is a hung jury, I would say that is the manifest necessity. The way that the statute is written doesn't say that the trial court is required to have them deliberate longer. It says as long as they've been deliberating for a reasonable amount of time. And in this case, the trial court actually put in his decision and order that it was the only feasible option at that point is to declare a mistrial after they indicated that they were deadlocked. So Under the manifest necessity standard, I don't think there is a further inquiry that needed to be made once both the foreperson and the jury as a whole indicated that they were deadlocked. Now, the courts have also said, the Supreme Court of the United States has also stated that you don't have to say the magic words manifest necessity or make an explicit finding. So the trial court did have the discretion to terminate the proceedings once we had the issue with the verdict forms and the jury was deadlocked. Now, although defense says that I inaccurately stated the case law where an Allen charge would be coercive, that's not accurate. I think that's an accurate summary, a synthesis of the case law on Allen charges is, and then even in People v. Patrick, this court, recognized that if any sort of instruction from the trial court can be seen as coercive, then that affects the defendant's rights. So in this case, the Allen charge would have been coercive. And again, Mr. Hattori doesn't really brief that issue, but I think I synthesized the law where, it explains how a jury can be feel that they were coerced. And the trial court in his decision and order indicated exactly that. He said that he felt that the jurors would have been incentivized to vote according with the initial verdict they had, which only at that time the trial court knew, not the parties. Now, for the issue about whether the second degree CSE, whether there was an implied acquittal because second degree CSE is a lesser included offense, this court has repeatedly explained that second degree CSE is not a lesser included offense, a first degree CSE. Now, defense says that, well, these are other circumstances where that rule would not apply, but that's actually not the law. In all the cases where this court has stated that, you've analyzed HEC 105.58, which is the double jeopardy codification of all the different ways that someone's double jeopardy rights may be violated. And this court has vacated second degree CSE convictions when they've been given as a lesser included offense. So because of those rulings, there was no lesser included offense. The defense cites to multiple cases to support his position, but those cases are an opposite because in the homicide case that they cite, that's a completely different scenario where a jury is given a murder charge and then they have to pick whether it's manslaughter or negligent homicide as lesser included offenses. The jury was not given alternative theories here. It was they had to find touching and they had to find penetration separately. So those arguments do not apply here.
But doesn't our law say that if the lesser included offense is separately charged, it still remains a lesser included offense?
Yes, but I mean that is the law, except that second degree CSE is not a lesser included offense here. Because it's not a lesser included of first degree CSE. So yes, even though it's separately charged, it still can be a lesser included offense. It's just not here under our case law. And so this is a case where the jury was not silent. Silence in those cases meant they completely didn't check off boxes or and there was no inquiry by the court as to what charges they were actually deadlocked here. Here, there is a record of it because the court asked twice of the jury whether they were unable to decide on the charges. So that is the biggest, I think, difference between the cases that defense cites and this case here. So because of those, because the jury was not silent and they indicated that they were truly deadlocked, it does not preclude the government from bringing back the charge because it was not an implied acquittal. And there is just no authority cited by the defense where because this was the same act or can be construed as being from the same act, that we are then precluded from retrying that charge and retry, especially after
If
the.
it's the same course of conduct, wouldn't double jeopardy apply?
So if that's a closer question, and I think that's fact specific, whether that applies. So if it is this, it is true that the double jeopardy statute says that if it's continuing course of conduct that it may apply, but that law is actually blurry when it comes to criminal sexual conduct cases. That particular issue has not been decided by this court so far. What if in a CSC case, what is included as continuing course of conduct? In the People v. Martin case, this court says that every single penetration, even though it's during the same episode, can be sentenced consecutively and distinctly, even though it's like the same day, because in the Martin case, we say every single penetration counts as its own violation of the first degree CSC statute or whatever sexual penetration statute is at issue. So here, and the reason why that's also problematic for this case is because there were so many charges. So we would have to go through an intense fact-finding process to see what in fact was continuing course of conduct, if anything, in this case. But the defense did not argue that, and we didn't use the transcripts from the case to go through that fact-intensive process because they are merely attacking the procedural grounds by which we got here. So this is a case where I think that the trial court's discretion in declaring the hung jury should have been addressed then and not now when it's post the first appeal and we're ready to go back to trial at this point. This should have been decided at an earlier date, but even if it was, the trial court.
I think it was pointed out that in the first case, there was a dismissal without prejudice, and there's no final judgment in that particular case in which Mr. Hattori could have appealed from as a final judgment.
So the way I see that is this. When the judgment issued for the one count of second degree CSC, in the judgment, it explains the disposition of what happened to the rest of the indictment.
And it was dismissed without prejudice, as you pointed out.
Right. And so I'm aware that recently in People v. Simmons, this court says a dismissal without prejudice is not a final order, but he should have attacked the declaration of the hung jury separate and apart from the dismissal of the charges of with or without prejudice, because those are separate issues.
How would that come up before our court? I mean, that's an interlocutory appeal. That's discretionary. And, we're talking about a very important right of the defendant in reference to standing trial twice for the same alleged violations. And if the initial proceeding has not concluded, I'm having difficulty with your argument that it should have been raised at that time.
I understand. And I think the issue is, the real issue is that they would not have argued this if we got affirmed in the first appeal. And so that's where I'm struggling, is we're resurrecting issues that could have been, even though there was no final order on those charges, he could have still attacked the declaration of the hung jury. He could have said, the way I see it, those are different issues.
It was decided already in his favor. You dismissed the charges.
Correct. Yes, I eventually dismissed the charges, but in the interim, if you look at the timeline, he never attacked the hung jury, even by way of motion for reconsideration. So there's no record that was made. And I think that's where I'm struggling, is because there was no record made closer in time because he didn't see issue with it even before I dismissed the charges without prejudice. And what I'm saying is, it wasn't an issue for him at that time, but it's only an issue now because we have reinstated the charges.
And I'm pointing out, DeSantis, is that at the posture of the case when he did appeal, the conviction of the second degree CSC, that was the adverse decision on that first trial to Mr. Vargas, and then he appealed it. He prevailed. It went back down. When there's a when the government then charged all 10 counts as the result of that, then he then filed his double jeopardy motion.
Understood.
Why is that not a timely exercise of his rights?
So I understand the court's position, and I just, the reason why that the government is taking this position is because if you think about the law of the case doctrine in general, these issues could have been fleshed out before. And so even before, again, I'm just going back to before the dismissal of the charges.
But even if the law of the case, I mean, that's number one. It's not a hard and fast rule. Number two, it goes in most instances to legal conclusions. And here, in reference to a hung jury, that's fact intensive, as we've seen from the first trial as opposed to the second case. Those are fact intensive review in reference to the reasons why the trial court may have declared or concluded that the jury was hung. There was a hung jury.
Understood, but the reason why I don't think it's timely is because I think he could have exhausted his remedies before the first appeal.
He could have, but he was not mandated to do so.
Correct. Yeah, so I believe that, yes, he wasn't mandated, but I'm just putting this on the record that we would not be here if he just was timely in all of his procedural. Yes, he was not mandated to, and I know the law says that you are not mandated to make a motion to reconsider, but the position is when the court declared a hung jury on the rest of the charges, but said, okay, well, there is this one guilty verdict for this charge. When procedurally they were going to attack the conviction, I think that they are permitted to attack everything and say, well, in this first appeal, part of the judge's order dismissing the charges, we want to address that in the first appeal. I don't think they were precluded from doing that in the first appeal.
You would have had to have filed a interlocutory appeal as to those charges that were dismissed without prejudice. And then it would have been discretionary on our part.
Agreed.
Whether we wanted to take up that appeal, recognizing that he's not foreclosed from taking that appeal up at the appropriate time or at another time.
Agreed. And so I agree that it would have been an interlocutory appeal that this court had the discretion to deny. My position is this court would have the discretion to have denied that closer in time to when this all happened versus we're here 4 years, 5 years later trying to litigate.
But it just doesn't seem right to have brought it up at that time without the indictment of those additional counts. I mean, the reindictment, because you may never have done it. You may never have gone forward with the reindictment on any of the offenses.
So, and I understand, it's just that right now in the year 2025, he's saying the judge in the year 2021 did not have manifest necessity. But to attack the manifest necessity determination, then why didn't you bring it up in the year 2021? It was just not an issue. So I understand though that the court, when I'm making these arguments, I'm going through every single argument that can be made. Understood that if this court doesn't believe that the appellate review is precluded because he had timely is exercising his rights now because we have reinstated the charges. I think the crux of the issue is we are still allowed to go forward on all of the remaining charges because they were not barred by double jeopardy and because the defendant consented to that mistrial. And so that I think is the real issue here. And I believe that based on my arguments that there is not a double jeopardy violation and the trial court did not abuse its discretion in declaring the mistrial.
I have no further questions. No further questions. Mr. Hattori, you have 2 minutes.
And in considering your 2 minutes, Mr. Torrey, at least from my mind, Ms. Santos points out, the government points out that the trial judge didn't act too hastily, that it was deliberative, and it was considered in in reviewing whether or not there was a hung jury. That's the bottom line of her argument.
That's correct, but I don't know if the record supports that. And I mean, she keeps referring to a sidebar, but I'm not sure what she's talking about because the record that is before the court shows that I was asking for the jury to get instructed or to ask if they can further deliberate, and then the government said, well, it would be coercive to send them back. So the court can issue an Allen charge. And I think it can be found to be an abuse of discretion where the trial court relies on an erroneous statement of law. And that's why we made the goading argument that the government kind of goaded the court into saying it was coercive without providing the basis for believing it would be coercive. So that's, I mean, the abuse of discretion standard would be met if the court were to find that the finding of a hung jury was based on maybe a mistake of law, and that the court believed that it would be coercive to further inquire just because they've read the verdict form. And I'm pretty sure historically they always read the verdict forms before they determine it's hung, or they haven't checked all the boxes, because that's how they find out they haven't checked all the boxes. And so we think because the court relied on an erroneous statement of law that constitutes an abuse of discretion. And I've gone way over my time. Thank you.
All right, thank you, counsel. The court will take the matter under advisement. We will issue a written opinion and will now stand adjourned.